There's been a lot going on in the First and Second Amendment auditing communities over Olmos Park. And one of the laws that has been contentious is the Olmos Park, Texas Code of Ordinances. This is 24-85, unauthorized carrying of loaded rifle or shotgun. Shall be unlawful for any person other than a duly authorized peace officer to carry a loaded rifle or loaded shotgun on any public street within the city. A rifle or shotgun shall be considered loaded if it contains a shell or shells in either barrel or magazine. One of the things that people are saying, and they're not really citing anything to do it, but they're saying that this particular ordinance has been preempted by the Constitution of Texas and or by the legislature, by the state legislature of Texas. And that may or may not be the case. Before we actually get into it, I would like to point out that it's not the role of the police officers to determine what is or isn't a constitutionally valid law or a law that has or hasn't been overturned. That's not their role. The police officer's role, they've got this law on the books. It's the police officer's role to enforce that law. The police officer enforces the law, issues the citation or arrests the suspect, and then the court and the lawyers will present arguments that this law is or isn't valid. The court will then determine whether or not that law is valid or isn't valid. So it is not the role of the police officer to determine. I know people are going to try to say that, oh, well, you know, the police shouldn't try to enforce any unconstitutional law. The police aren't lawyers. They haven't gone to law school. They're not judges. It is outside of their realm. It's outside of their scope to determine whether or not a law is constitutional under the Texas Constitution, whether it's been preempted by other statutes. That's not their role. So the first place we want to go to determine whether or not this particular city ordinance has been preempted by the Texas Constitution is the Texas Constitution itself. Here we are in section 23. It's the Bill of Rights, which is Article 1. Article 1, Bill of Rights. Section 23, the right to keep and bear arms, regulation of wearing of arms. Every citizen shall have the right to keep and bear arms in the lawful defense of himself or the state, but the legislature shall have the power, by law, to regulate the wearing of arms with a view to prevent crime. Now, the argument that you would have to make to say that this preempts the right of the city to make a statute would be that the legislature does not have the power to delegate its authority to the cities. And we will see that that is not necessarily the case. This is from the Office of the Attorney General in the state of Texas. This is a letter of opinion. It's 94-56. So this was an opinion offered back in 1994. And the question at hand was whether local government code 215-001B2 made this Houston ordinance. This is the city of Houston. This is one of their ordinances, discharge of firearms by minors. If this ordinance, or if this the statute preempted this ordinance. Now, he doesn't address the Texas Constitution. He doesn't say, well, you know, the Texas Constitution will make it, will preempt it. So he actually addresses this statute. Now, this statute in turn has become 229.001, which we will be looking at. But what he goes on to say is that because this ordinance, was couched in terms of preventing discharge of firearms by minors, even though it makes it unlawful for any adult to intentionally, knowingly, recklessly, or with criminal negligence to facilitate, suffer, or permit the physical possession of a firearm by a child, by allowing the child to obtain unsupervised access to the firearm. So this is restricting what an adult can do, right? So in his opinion, he felt that, here, let me just go to the summary. A home rule city ordinance directed at the prevention of discharges of firearms by children does not on its face violate local government code section 215.001, which bars municipal regulation of inter alia the keeping of firearms, since the ordinance falls within the field of regulation of the discharge of firearms specifically reserved to municipalities by the statute. So the purpose of me bringing this up to you was to show that you can, at least in the opinion of the Attorney General of Texas, that first of all the Constitution doesn't prohibit it, and second of all there is precedent that the cities can do some limiting of firearms or some control of firearms. That 215.001 is now 229.001. This is miscellaneous regulatory authority of municipalities. I am in statutes.legis.state.tx.us. This is the official state legislature of Texas. So 229.001, firearms, air guns, knives, or explosives. Notwithstanding any other law, including blah, 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 a municipality may not adopt regulations relating to the transfer, private ownership, keeping, or transportation, licensing, or registration of firearms, air guns, knives, ammunition, or firearm or air gun supplies, or the discharge of the firearm at a sport shooting range. So right there, it does appear that the city of Olmos Park is regulating the keeping or transportation of firearms and ammunition. Because we go back and we look at this, it shall be unlawful for any person to carry, that's keeping or transportation, a loaded rifle or shotgun, that is a firearm, on any public street within the city. And it has to be loaded, so that would be ammunition. A rifle or shotgun shall be considered loaded if it contains a shell or shells in either barrel or magazine. So that's ammunition. So there, it does appear that 229 does not allow for it. So the next thing you have to do is you have to look to see if there's some sort of an exception. And so subsection A does not affect the authority of a municipality has under law to require residents or public employees to be armed for personal or national defense, law enforcement, or other lawful purpose. So that doesn't apply. Regulate the discharge of firearms or air guns within the limits of the municipality other than at a sport shooting range. That doesn't apply because they're not talking about discharge. And in fact, they have regulated unauthorized discharge within city limits. So so that doesn't apply to carrying a loaded rifle or shotgun. To regulate the use of property, this would be real property, the location of a business or uses it business under the municipality's fire code, zoning ordinance, or land use regulations, such as the code, ordinance, or regulations not used to so long as the code isn't used to circumvent the intention of subsection A. So what they're saying is, I think it's section 315 of the Texas Local Government Code. I don't have it up here, but I believe it's section 315 that does zoning, and it allows the zoning ordinances to restrict firearms discharges to prevent fires and things like that. So that doesn't apply, because they're on a public street at this point, and you're not going to catch a public street on fire, not without going out of your way. To regulate the use of firearms, air guns, or knives in the case of an insurrection, riot, or natural disaster, which they do. If you watch Bunny Boot's stream, it hasn't finished rendering yet, but he did a stream where in the radio traffic, one of the officers radios in that the rebellion has been crushed or something along those lines. If there was an actual rebellion, an insurrection, or riot, then the municipality would have the right. It's actually kind of funny, because Bunny Boots thought that it was somehow damning to the police. But if the city of Olmos Park was under the belief that there was a rebellion, an insurrection, a riot, then they actually would have, under this, the authority to regulate the use of those firearms. So, regulate the storage or transportation of explosives. I don't think this would, they don't define firearms as explosives. So, I don't believe so. Regulate the carrying of firearm or air gun by a person other than a person licensed to carry a handgun. Oh, maybe this is it, right? At a public park. Well, it wasn't at a public park, so no. A public meeting of a municipality, county, or other governmental body. Nope, he was just on a public street. A political rally. Oh, maybe. Maybe. Parade or official political meeting. Maybe. This maybe. So we don't know. I haven't seen what anybody was charged with, but this might fit. Firearms related school, college, or professional athletic event. Nope. They can regulate the hours of operation. That doesn't fit. They could regulate the carrying of an air gun by a minor. Nope. It's not an air gun. It's not a minor. And then the subsection B6. B6 was this part right here. Does not apply if the firearm or air gun is in or is carried to or from an area designated for use in a lawful hunting, fishing, or other sporting event, and the firearm or air gun is of the type commonly used in the activity. So, yeah, these weren't for hunting, so this isn't going to be an exception to the exception. The exception in subsection B4 does not authorize the seizure of confiscation from an individual's lawfully carrying or possession. So B4, let's go back up to B4. This is in the case of insurrection or riot. So this is an exception to the exception. So it does not authorize the seizure or confiscation of a person who's lawfully carrying it. So that's, I don't know if they seized the firearm. So in this section, air gun, knife, sport, we don't care about that. The Attorney General may bring an action in the name of the state to obtain temporary or permanent injunction against the municipality operating or adopting a regulation violation of this section. So they're not giving you the right to sue under this. So, and they do maintain their state sovereignty. So there's a couple questions here. So the first one is this ordinance right here preempted by the Constitution of Texas? No, it's not. Does not appear to be. Maybe, but it doesn't appear to be. Is it preempted by the state legislature? It does appear to be, because this isn't not an ordinance talking about it's not an ordinance talking about in case of rebellion, it's unauthorized to carry a loaded rifle or shotgun. This is just a blanket deal. So this doesn't appear to fit any of the exceptions. So this does appear to be preempted by the statute 229. And the Attorney General doesn't feel that the Constitution preempts municipal ordinances that regulate firearms, as long as they're secured in. It doesn't believe the Constitution applies, and then as long as it appears on its face to be within the scope of one of the exceptions, then unless it goes outside of that scope, he's basically said that he's not gonna get involved with it until it does. So yeah, I hope I've rambled enough. Always, before you say something has been preempted, you probably want to make sure that you know what you're talking about. Too many people were just saying it was, and you sound stupid if you don't know what you're talking about. Other than that, have a great day and keep auditing.